One of the most courageous things you can do is to know yourself, know who you are, what you believe in, and where you want to go. With step, welcome one and all national on carceral feminism. Celebrate National Women's Day today. First, I would like to extend my sincere thanks to the management of Babu Banarasi Das University, our chairperson, ma'am, Mrs. Arika Das, our vice chancellor, sir, Dr. A.K. Mittal, our in charge, School of Legal Studies, Professor Dr. Geetu Singh. Here, I would also like to take a moment briefly to introduce our Chief Committee Convener, Dr. Rajesh Kumar Verma, sir, our event convener, Ms. Muttal Swati. We welcome you all. Here we also have the privilege for our guest speaker of today's event, Ms. Swati Singh Parmar. Women are strong, powerful, and invincible. And they are always like so from the beginning. Times have shifted when this day was seen as a mark of empowerment of women. Now, it marks and acknowledges their achievements in all aspects of life. Whether she is a teacher, a homemaker, economist, engineer, or a pioneer, women have been working and making the world a better place with their infinite strength, determination, and belief. With power enough to shatter the shackles of patriarchy, women are rising above the societal hurdles each and every single day, making them stronger force to reckon with in today's modern times. That said, every sphere has a scope of improvement and attention to be taken care of. And so, on this International Women's Day, we bring before you a very relevant topic of feminism before you all. We are fortunate enough for this to have with us our distinguished guest, Ms. Swati Singh Parmar, Assistant Professor, Dharmashastra, National Law University, Jabalpur. Ms. Parmar, a merit scholarship holder of University of Allahabad, also received Gold Medal and Excellence in Knowledge Creation Award from Amity University. Her area of interest includes international legal theory, international legal history, and jurisprudence. She has diploma in diplomacy in modern world and also in global diplomacy, the United Nations in the world from SOS University of London. She has authored a book titled An Introduction to International Law, published by Thomson Reuters. Besides that, she has, to her credit, published 5 book chapters and 10 research articles in international research journals on international law. Ms. Parmar is a member of International Society for Therapeutic Jurisprudence, Canada. Also, a member of Global Network for the Study of Human Rights and Environment. She is a life member of the Indian School of International Law, New Delhi. Before we move on, a gentle reminder for our YouTube viewers that you may post your queries relevant to today's topic in the YouTube chat box. Now, I request Swati ma'am to bless our attendees with her expertise and insights on the topic of carceral feminism. Ma'am, over to you.
Thank you so much, Parishkar sir. Such a kind introduction. And I thank the university and dean and all the members who have organized this session for inviting me today. And I'm not sure whether I'll be able to bless or not, but yes, whatever little knowledge I have about the subject, I'll try to share as much I can within the given constraints of time. So today I'll be talking about carceral feminism. And why am I talking about carceral feminism? So I wanted to evade from the cliche rhetoric of discussing about feminism, which is sadly sometimes reduced to a lip service, especially on International Women's Day. So it is only International Women's Day, 8th March, that we are reminded of feminist discourse. And I did not want to carry forward the same legacy. And just to break that, I have chosen this topic, which I believe most of the scholars who are interested in feminism would be maybe aware of the word or the concept. But I'll try to share what I know and what I have read about carceral feminism. So, can we have the second slide? Yes, thank you. So, what exactly is this term carceral feminism? Carceral, this word etymologically comes from the word carcer or carceralis, which are Latin terms for the word carceral. And it basically means something related to or belonging to a jail or a prison. So, carceral feminism is basically an approach in the feminist criminology discourse which places larger reliance on punitive acts to control the sexual and the gendered violence in the society. So there are various ways of addressing the sexual and gendered violence that we encounter in our society, which are very disturbing. Law is one of the solutions, as portrayed by most of the law scholars. But this specifically, this carceral feminism is the one that, especially in law also, it places emphasis on punitivity. So punitive actions of the state are seen as a primary tool to help the feminist discourse address the problem of sexual offenses. Now we'll see whether this line of argument is workable given the situation of our society, especially in context of Indian society, or it is not workable. How far it is good, how far it has some loopholes. So the carceral feminist, those who call themselves as carceral feminist, they realize the importance of prison and prison system in a political state, and they see that the possible answer to the sexual violence in the society is criminalization. So let us have more laws. Let us criminalize more acts of sexual violence. And when we criminalize more acts, when we have more criminal laws, more penal offenses placed in the acts and statutes, that would possibly be a good answer to all the sexual violence. This is their basic premise. So, carceral feminism as an approach in the broader paradigm of feminist criminology says that let us increase policing, let us increase the prosecution, let us see the conviction rates, and let us make the punishments stricter and harsher. So, harsh, strict, and longer punishments is one argument that branches out of carceral feminism. Now, whether this harsh punishment actually helps in reducing the sexual offenses in the society or not, that is a debate that we'll take later in the course of this discussion. Now, what essentially is it that we're doing in carceral feminist discourse? We are focusing on an individual as the convict or the perpetrator of a sexual offense, and we are trying to stop him through the laws, through punishing him or her. And also in this way, we are giving more power to the state judicial apparatus. So we are placing more expectation and therefore more power in the state, in the judiciary, in the courts of law, and in the existing legal system. And we are trying that this increased punishment and the longer sentences, harsher and stricter sentences, and more number of laws to criminalize the sexual offenses would actually reduce the sexual offenses. But this assumption, we'll see that whether this assumption actually comes to be true or wrong through an empirical study towards the end. But yes, to understand carceral feminism is one feminist discourse that says that yes, prison, punishment, and prosecution, these are the answers to sexual offenses. Whatever problems are there, the most potent, strongest element that can solve all the sexual offenses is prison system and criminalization. Now, we of course know, we must have been aware of lot of judgments where judges have penned down the importance of strict punishments and harsh punishments depending upon how heinous is the crime. So, so for a rape of a child, there is, which actually invokes the moral conscience of the society, a judge would say that no, for this particular case, this is a special case which requires harsher punishment. Rape of a teenager, maybe a gang rape of a teenager, is, a judge would call that no, this is a very heinous crime and this is ugly and vulgar display on the moral depletion of society, and therefore this case needs not only imprisonment but maybe death penalty. And therefore we have a separate set of debate, which is the abolitionist versus retentionist debate, that whether to abolish death penalty versus whether to retain death penalty. So I'll not go into that debate, but yes, we must have read some judgments in our readings of Indian Penal Code on how special cases require stricter and harsher punishments. And I think as law students, we have stricter and harsher laws as the ready, tailor-made, go-to answer for every problem in the society. And that takes us to other finer details of carceral feminism. Now, carceral feminism also sees that law is a necessity. Law, of course, is a necessity, but especially in the realm of addressing sexual violence in a society, laws are indispensable, which might be true. But the argument of carceral feminism that says that we should solely depend on state, because state has the authority to pass laws and laws to criminalize sexual acts, is our one go-to answer. So carceral feminists have displayed their sole dependency on state mechanism, and in a way it is also argued that is why many states have become what we know as carceral state, a state that criminalizes a lot, a state that sees criminalization as an easy answer to every problem in the society, that makes a state a carceral state. So for every problem, there is a prison. Now we don't know whether this is right or wrong, because we know the condition of prisons, we know the overcrowding of prisons, we know series of cases of serious fundamental rights and human rights violation of the convicts inside the prison system. So we are aware of the practical problems of the Indian prison system and in general the prison system across the globe. So although here we are seeing prison as a solution, theoretically it may sound emotive, it may sound evocative, but whether it actually on ground can be a solution or not, that remains a question. Now, in placing reliance on laws, criminalization, prosecution, and prison, we often overlook few important things. And these important things are structural issues that are imbibed by the social fabric. So, for example, we don't talk about the existing patriarchal environment that we have in our social, legal, political, and economic structures of state. So, for example, the the powers of the positions of power or the positions of visibility in each of the wings of state, legislature, executive, judiciary, and their subsets, is occupied by males. So this is an example by number. I'm just talking about quantitatively, but there are several other discussions qualitatively to show that existing patriarchal environment is the one in which we all breathe in. And this patriarchal environment channelizes toxic masculinity, where, so it's not that a male has to be masculine or a male has to be patriarchal. A female can equally be patriarchal. A female can equally be an epicenter of patriarchy. So this patriarchal environment around us has built a toxic masculine culture. And all of this has been important catalyst in creating a cycle of abuse and violence. So, for example, if we go into deconstruction and we try to deconstruct semantically the words abuse or violence, they are connected to strength, power, authority, all that by nature is masculine. So this is just one example that I'm sharing, that there is a cycle of abuse and violence that we have created around us, very subtly, sometimes loudly, which we do not realize, and therefore we do not acknowledge, and therefore we also do not address, but we avoid these problems that are so ingrained in the society that we overlook. And we talk about artificial created systems of state like prison as a solution to sexual offenses. Also, there have been scholars who have shown their studies empirically to prove that all the three peculiar problems that I mentioned, which create this cycle of abuse and violence, sexual violence especially, prison system is a prototype of it. So prison system actually perpetuates all these problems that I just shared with you all. And avoiding a discourse on this, and instead of discussing these issues, but instead of these talking about prison and criminalization, actually deviates us from a very important concept of transformative justice. So I'll not discuss more on transformative justice, but yes, these issues are strong impediment in our discourse on transformative justice as well. So, for example, if we talk about prison system, there have been series of discussions, formal and informal, by the Law Commission of India or amongst the legal scholars on prison reforms, on transforming the situation of prison, on thinking beyond punitive and retributive theories, on talking about reformation maybe. But then this idea of carceral state or carceral feminism that draws our attention towards prison system again drags us back in time and it regresses us to think punitively, to think retributively, and not concentrate or not talk about reformation at all. And why essentially are we doing so? Why are we talking about criminalization so much? Why are we talking about prison system so much? Why do we see law as the godfather? So this is because we all, as especially the law students, we all think law to be a panacea. So we see law as the savior, law as one entity which can solve all the problems, and whatever problems are there in the society, they are there because we don't have efficient laws. And this debate, this argument has gone so far that it has built its own regime in the form of carceral femininity. So when we see the definition of law, for example, if we see the definition of law given by John Austin, it revolves around the trinity of command, sanction, and sovereign. So law is the command of the sovereigns backed by sanction by political superior upon political inferior. So what is this sanction? Sanction is something that ensures the enforceability in law. So not only a law is important, but also a sanction is important so that law is made, it may be enforced, it may not be enforced. But law is, to make sure that law is enforced, we need to have one element, and that element is called sanction by John Austin. Now, most of us have read punishment as an example of sanction. But what we don't discuss, or rather what is not there in the general discourse amongst legal academia, is that sanction can be positive as well as negative. So the example of negative sanction is placing some inconvenience upon the individual by the state in case of disobedience of a law. And that inconvenience can take the form of a punishment, can be a fine, can be imprisonment, etc. But we don't talk about positive sanction. So positive sanction is something that is not an inconvenience, but a benefit that an individual qualifies to get, where the individual obeys a law. And such positive sanction, examples of such positive sanction could be a reward, a motivation letter, etc. Now, sadly, we all have the Hobbesian nature, as Thomas Hobbes has described in Leviathan, that human by nature is such that if in the absence of king, the life of human beings would be short, nasty, brutish. So we all are selfish by nature. And therefore, the selfish individuals that are there in the society, it is difficult to regulate them with positive sanction. It is difficult to give them reward. Many people would say that we don't want reward, so we'll not obey this law, but we'll disobey. So rather than concentrating on positive sanction, unfortunately, we created a state out of ourselves which concentrated on negative sanctions. We gave leverage to the state, and we all collectively created punishment as a sanction. And we don't even talk about reward as a sanction, because reward can equally ensure enforcement and compliance in a law. But then, yes, it's not as stringent as punishment is. So unfortunately, but yes, state adopted punishment as a sanction. Now, this punishment is stringent, it is strong, and it has a lot of collective emotions. We see strong punishment as something that makes a law very efficient. We see strong punishment as a speedy and ready-made answer by the state for such sexual offenses. And then this is amplified by a lot of melodrama. We have a lot of movies, especially cinema has placed over-reliance on arousing the collective emotions out of strong laws and speedy prosecution and punishment for the villain in the movie. And this has given a very good effective ground for breeding populism. So there are studies that show that how political parties, how politicians use this carceral agency, use this impulse that we derive out of carceral agency, and how they use this to manipulate the vote banks. So, how one particular category of offenses is taken very seriously, that not only depends upon the gravity of the offense, but also how, through the political spectrum, it is seen as a strong emotive which would have some bearing on the vote bank. And this whole phenomena is popularly known as penal populism. So a party or a politician becomes popular by penalizing or criminalizing things that people want to criminalize. And then what after that? Criminalizing, is that a solution? No one knows unless an empirical study is conducted. Also, whether increasing the punishment or harshness or length of the punishment in a particular provision, what bearing it has had on reducing the sexual offenses, for this we have to look to some study, some empirical data. We cannot directly act like politicians and say that yes, strong laws will ensure that there are no rapes. Strong laws, strong punishments, or strongly worded judgments would ensure that there is no gang rape. It may act as a strong deterrent, but this too I'm saying theoretically. I also have to conduct a study to actually jump to the conclusion that it acts as a deterrent. So seeing prosecution as the only key to gender justice, the only key to stop all the sexual violence in the society, is something that really needs to be discussed, read, and critically analyzed, maybe substantiated by some study, some ground study. Also, this I say because we all know that criminal law in the first place is already a solution to a lot of problems in the society. So we try to, there are so many criminal law amendments, there are so many other laws that substantiate the existing Indian Penal Code. So there is prevention of sexual harassment of women at workplace, there is POXCO Act, there are several series of acts, series of central legislations and state legislations that assist the existing Indian Penal Code 1860. So state essentially has created lot of prisons, lot of cages for too many people through law, but the solutions still are not known. Reformation still has lot of scope in this example. And while criminal law may be an important and a potent solution or a remedy to sexual offenses, but it is not the only one remedy available. There are remedies available outside law. And that is why I say that law is not the panacea. Law may be a panacea in some or the other case, but always for every situation, law cannot be the panacea. You have to find answers in sociology, in anthropology, in psychology, etc., especially for our discussion of sexual and gendered offenses, because this has a lot to do with other things beyond law. And also, when we talk about criminalization, when we talk about harsh and strict punishments, which is the focus of carceral feminism, we are again reinforcing one thing that has been seen as a problem in criminal law, and that is the binary of victim and perpetrator, the taboo of victim and perpetrator, the public shaming that victim and perpetrator both undergo. So criminal law jurisprudence times and again evolves and tells us that no, victim perpetrator binary is something that is very parochial, and we need to address this, and we need to see crime as an act and not as an act committed by this particular criminal. So we really have to rethink, when we talk about carceral feminism, we really have to rethink that, are we accepting to again reinforce the victim perpetrator binary, which already is the root of so many problems in the society? And when we reduce this whole problem of sexual offenses to victim perpetrator, we talk in numbers, we talk about individuals, but we forget the larger problem that exists in the patriarchal society that in which we inhabit. So we basically digress from the essence of our discourse. Now, carceral feminism is seen as one of the variant of justice, one of the variant to arrive at justice in cases of sexual and gendered offenses. And there are many feminist groups who actually argue for strong laws. But then there also are scholars who actually disagree with carceral feminism, and they show their skepticism of carceral feminism, and they say that this actually is strengthening the already strong state. So if we try to see how many forces are there in the state, in our society, that violate fundamental rights, we'll arrive at a conclusion that at least quantitatively, state is the biggest violator of fundamental rights. And state is already very powerful. And we are strengthening the state again to address something which, the problems of which, the roots of which lie in our society, in our psyche, in the ways we have created our socio-legal political structures. So we are again relying on some artificially created system have borrowed answers of sexual violence from society. So social reflections of answering or addressing sexual violence may have been adopted by a law. It may not have been adopted by law. And in situations where it is not adopted by law, that law usually falls into disrepute. It does not solve the purpose for which it had come in the initial stage. And this argument that I say, that scholars who have been skeptical of carceral feminism, one of those is Professor Prabha Kotiswaran, who in 2018 wrote about the reforming Indian rape laws, and especially in the backdrop of post-coloniality. Now, moving ahead, especially in the context of Indian situation, if we see what are the existing laws in our legal system that address sexual violence, we'll see that for a long period of time, from around 1983 to 2013, there was no situation where criminal laws were amended in India. And suddenly, after December 2012, 16 December 2012, with the unfortunate, extremely bad and disturbing rape of Delhi, the Delhi gang rape, that was a time that instigated debates amongst the legal fraternity and the feminists, who said that we really need to rethink the ways we deal with sexual violence. And the incident shook the national conscience, so much so that there was debate everywhere, and which essentially channelize the major amendment in Indian Penal Code after long, Criminal Law Amendment Act 2013. And afterwards, there also, just after 5 years, there was another amendment in 2018 in the criminal laws. Then these are major amendments that try to look at answers to address sexual violence in the contemporary times, because they are contemporary revisions in criminal law. Then besides these two important amendments, there is POCSO, Protection of Children from Sexual Offences Amendment Act, that increased the threshold of punishment. Then, if we talk about state legislatures, Andhra Pradesh State Legislative Assembly passed an act which tried to introduce death penalty for rape. So it amended the existing Indian Penal Code for Andhra Pradesh state by introducing death penalty in cases of rape. So we see, I'm sharing these examples because we see through this that India has large number of laws to deal with sexual offenses. And we have had recent transitions also because of these amendments to deal more strongly or more efficiently with the issues of sexual violence. But there have been rare studies to show what actual effect these amendments have had in reducing the number of sexual violence. Now, since we have talked about so many amendments in the Indian criminal laws to address sexual violence, on the contrary of it, on the other side of the debate is the arguments that show us the problem with the existing prison system and the police system. So, for example, there are thinkers who say that the existing police system in India is actually a colonial relic, and it is the gift of the British during the colonial era, and it has not underwent enough reforms to actually deal with the contemporary problems. Also, there are studies that talk about the structure of police system and how this structure of police system actually makes the police not answerable to people in large, not answerable to the state. So, for example, there's one study that says that the police system embodies a pyramidal structure. So, there's a pyramid-like structure in which the top positions, which are the supervisory positions, are occupied only by 1% of the total entire population of police system. And then at the bottom, there is 86% of population of the entire police system, which is engaged in constabulary. And this 86% of constabulary are the ones with whom the common person interacts on a daily basis. And this structure of police system makes sure that the 86% and everything barring the 1% at the top, so the 99% in a sense, is actually made to think that you are answerable only to your administrative superior. And you're not at all answerable to the individuals of the society. Now this is something very interesting. Also, so this is only about police system, but if we talk about the legal system that tries to talk about policing, Professor Upendra Bakshi has noted in one of his articles titled "The Crisis of the Indian Legal System," he says, when a decolonized state inherits the colonial policing system that does not adapt itself to the aspirations of a free nation, it inadvertently inherits a colonial repressive police organization and political regimes that exist to serve the governing elite. So he starkly argues that we have adopted our police system from the colonial past, and colonial reflections still exist, and we have not adapted to the needs of contemporary India, which is a free India, a free nation. And therefore, automatically, inadvertently, we have inherited a very repressive kind of police organization, which seldom violates the fundamental rights of the individuals, common people with which it interacts. And it automatically also breeds an environment where they think that they have to serve the governing elite. They are the agency of state, so they have to serve the state or the elites in a society. Now, again, on carceral feminism and ideas of justice in India, this is uh, one study that is published in a blog written by Sanjukta Bose. And she writes that police system in India is inherently tied to the caste system, upheld by principles of Brahmanical patriarchy that work to uphold the status quo and quash minority rights. So this is another example. So the words of Upendra Bakshi remind us how colonial is our policing system and how we have not addressed that coloniality in the existing policing system. Now, these words from the second example, the second quote tells us that this police system also is a place where we can see strong caste discrimination. So, for example, there are several studies that have shown the number of individuals that are taken into custody by the police, and the social profiling and the caste profiling of them. So the number of individuals belonging to scheduled caste and scheduled tribes are picked up and put into custody by the police system more, especially during the lockdown era. And those who do not belong to marginalized sections of Indian society, their proportion in the people who were there in custody was extremely less if compared to the demography of the state. Now, this is something very stark. So these are just few examples that I'm sharing, which are problematic in the existing polling system, be it the discrimination on the basis of caste, be it discrimination on the basis of social profiling, elites and non-elites, haves and haves not, be it the colonial nature of policing system. And then we also are aware of extrajudicial killings. Now, by extrajudicial killings, I'm reminded of an example of Hyderabad case of 2019. It also evoked national conscience, where a female student was gang raped by 4 men, and they were encountered by the police, and the police told the state that they were trying to flee from police custody, and that was the reason that they were encountered. Now, it had different varying reactions from different parts of society. Sometimes it was applauded an act of strength of police, efficiency of police, and valor and power of police. And it was by others, it was also criticized that how wrong it is and how it is an extrajudicial killing, and how the procedure and process were evaded, and encounter is something which has an important critique from human rights activists, and what bearing it has on illegality of the act of encounter. So we are aware of extrajudicial killings, we are aware of the human rights that are violated inside the prison, the extrajudicial killings inside the prison violence, and knowing all these situations of the police system and the prison system, we are arguing for carceral feminism. We are arguing for law as the panacea for sexual and gendered violence. Now, this is a study. So I discussed about the amendments that were made to the criminal law in 2013, 2018, and then the amendment in 2019 to the POCSO Act. But in 2018, there was an interesting study by Thomson Reuters, and this is the study. I have placed the screenshot of the study. It is titled, "Is India Really the Most Dangerous Country for Women?" And shockingly, the study showed that India was named as the most dangerous country in the world for women. And unfortunately, it is worse than the states which are known for being bad to women, or the states which have some situations, for example, the war-torn states or the failed or weak states, which have situations that completely disregard the existence of women or completely violate the sexuality of women, and which are known for high number of sexual offenses and gendered crimes. So, for example, Indian situation from the point of view of safety for women, it was in 2018 survey, it was worse than the war-torn nations like Syria and Afghanistan. Now, this survey is after the Criminal Law Amendment Act 2013 and 18. So this sparked discussion that what actually is that what we have achieved after these amendments. So although these amendments theoretically sound very nice, they arouse our emotions that yes, strong law is needed and it is a good step. But in actuality, does it actually have some bearing on reduction of sexual offenses or not? And that can be told only by an empirical study, by looking at conviction rates, by looking at judgments, by looking at how many number of people have been convicted of rape, gang rape, and other kinds of sexual violence. Now, these are few works who have talked about how problematic is carceral state. So if we talk about policing and prosecution, how problematic it is. So for example, there's this scholar Anthony Bottoms who talked about how politicians, important figures in the state, how they manipulate the public anxieties surrounding the crime, and how they try to deviate the state from larger problems by creating a new law for a crime. So his work is a chapter in the book, The Politics of Sentencing Reform, and the chapter is named The Philosophy and Politics of Punishment and Sentencing. And there he talks how politicians manipulate these anxieties over crime. Now, again, I discussed about penal populism a few minutes ago. So John Bratt is a thinker who wrote a book titled Penal Populism. And in that book, he tried to show that how the political justice, the debates on political justice, has less to do with law and order situation in a society, or has less to do with public safety and security. And it is more like a political theater where a ruling party proposes a bill to address some crime, and it of course becomes popular, and the opposition party tries to introduce some amendment through which it makes the punishment higher to evoke populism. So how populism, how penalization and criminalization of acts has become a very important tool of populism at the hands of political parties. So, how this criminal justice is more of a political theater. So, there's one event which shocks the conscience of the nation, and one of the political parties thinks that, okay, we will bring a new law or we will bring an amendment making the punishment harsher, and that is applauded by the people at large, thinking that yes, this is the answer, this is the solution. But then the public would forget about it and would not actually come back and recheck how much good this amendment or this new law has had on reducing the sexual violence. Also, there are studies where scholars have shown that carceral state, a state that criminalizes more, and it takes criminalization as a response to threaten people, it actually gives lot of edge to the police organization to violate the rights of individuals and pick them up in the name of some or the other act which has harsh punishments. And especially it actually does more harm to the socially marginalized. So, for example, there are two studies. One is by Meda Chesney Lind on patriarchy, crime, and justice, feminist criminology in an era of backlash. And then the other one is Beth E. Ritchie's work, Arrested Justice, Black Women, Violence, and America's Prison System. So these two argue about how carceral state actually is harmful for the socially marginalized. Now, besides this, especially in Indian context, there are two studies that I like to discuss. One is on feminism and its discontents, punishing sexual violence in India, by Preeti Pratishuti Das. And it talks about the infamous Delhi gang rape and the J.S. Verma Committee's report, and how few suggestions from the J.S. Verma Committee report were picked in the name of carceral feminism, and how important and larger debates were actually overlooked, the debates that were suggested by J.S. Verma Committee's report. So this is one important reading that I like to share with you all. And second is a very pertinent study by Project 39A, which is run by National Law University, New Delhi. And this is a study on titled Punitive Responses to Sexual Violence Need Rethink Given Perverse Consequences. So we talk about strong laws, but what consequences does it have or will it have? We do not talk about it much. And that takes us to this very interesting study that I wanted to discuss. Now, I talked about carceral feminism, what it is, what are the basic premise of it, and what is the critique of it. Now, this is one important empirical study which is titled Rape Adjudications in India in the Aftermath of Criminal Law Amendment Act 2013. Findings from trial courts of Delhi. And this article is again from Preeti Pratishuti Das. Now, this article is built on some data collection from 5 years, from 2013 to 2018. And through a grounded empirical study, this article shows that increasing the punishment and defining more acts, for example, voyeurism, stalking, as sexual offenses, has had no bearing on the conviction rate. Rather, it has shown that the conviction rate that was there in pre-amendment 2013 and the conviction rate post-amendment 2013, there is a vast gulf between it. And unfortunately, the conviction rate has decreased. So let me share about the methodology of this article first, because this article not only is an important one for carceral feminism, but it also tells us about a strong research methodology through which we can actually arrive at fruitful conclusions. So the methodology that she adopts is a study of 1635 judgments, and she read these judgments, uh, and these judgments all were from the trial courts of Delhi for a period of 5 years, 2013 to 2018. And it tried to there were few search words that she used to find these 1635 judgments, like rape, sexual offense, sexual violence, promise to marry, penetration, penovaginal, non-penovaginal, and penetration. And then through these search words, she found around 10,000 judgments, which were then uh, segregated, and 1635 judgments relevant to the study were found, which were analyzed. And the conviction in the judgment was analyzed. Uh, how many judgments actually resulted in conviction? How many people were actually convicted by the courts in these 1635 cases? And this paragraph that I've taken from her study, I'll just read out this. So it says, an examination of judgments of rape cases adjudicated in Delhi between 2013 and 2018, however, revealed that these aims were far from realized. So the aim of Criminal Law Amendment Act was far from realized. Of these 1635 cases examined in this paper, 726 were adjudicated under the old law and 909 under the CLA, that is Criminal Law Amendment 2013. The average rate of conviction under the old law across the 6 years was 16.11%, that is 1117 cases. Under CLA 2013, this fell to 5.72%, that is a mere 52 cases. The already low rate of conviction of rape thus appears to have been further diminished after enactment of CLA 2013. So I'm sharing this article because this article was awarded the best article by Indian Law Review, which is published by Routledge and Taylor and Francis. And this was the best article because through a very strong research methodology, through numbers, it showed that Criminal Law Amendment Act of 2013 is not a solution for the sexual violence. Rather, it has become counterproductive to the cause of sexual violence, to the cause of avoiding sexual violence. So this is the only concluding paragraph that I've shared in the study, but I'll request all of you who are interested in carceral feminism or feminist discourse or feminist criminology, please go and read this article, because it tells how the conviction rate, which already is very low in case of Indian court system, Indian judiciary, how it is further lowered because of the realization in judges' mind that for rape and for gang rape or for any other sexual offenses, now the punishment is higher. Now the punishment is harsher, longer, and stricter. Therefore, there are more acquittals. Even when there is evidence, judges how have been bent on actually acquitting people, have looked for more possibility of acquitting people rather than convicting them. And this rate, so 16.11% before 2013 amendment, and when the 2013 amendment was brought along with harsher punishment, how the rate fell and it became less than half of 16.11. And this is a huge number. from 1117 cases of conviction to just 52 cases of conviction. So in conclusion, I am sharing this study just to make this argument to you all that we cannot have a blanket statement, a generalized answer, law as an answer to all kinds of sexual offenses and gendered violence in the existing society. We have to realize how patriarchal, how masculine we all are, and every answer is not in law. Also, it shows, it reveals how weak our presumption is that strong laws will make a safe society for women. It may not make a safe society for women. Especially this study shows that strong laws with strong punishment actually becomes counterproductive to the cause of gender justice. So we really need to think about our carceral feminist arguments that we casually use, and maybe look at some empirical data, empirical studies to understand that it's not as simple as law being an answer to every problem, because law involves agency of state, it involves agency of police, it involves prison system, all of which have their own breeding problems. So with that, I'll conclude, and I'm happy to take any questions.
And indeed, we feel privileged that we had an opportunity, Swati Singh. Now, ma'am, taking some of the queries, as we are short of time, so we are taking few of the selected questions. Ma'am, first of all, it's a question from Mr. Ishan Mishra. What are the most effective ways to counteract the negative stereotypes of feminism, especially at workplace?
Okay, thank you, Prashant, for your question. So, alternatives. Yes, so alternatives to counter the stereotypes. I'm not sure whether I know all the alternatives, but I think we should allow, strengthen, assist, and aid women around us to be there more in the workforce. So, for example, if you see the gender profiling of institutions, especially the educational institutions, we see, for example, I'll give example from my profession. I teach, and teaching is seen as a profession which is very friendly for women. So women see teaching as a go-to option as a for profession. But then if you try to empirically see the gender profiling of teachers across educational institutions in India, you will be shocked to know the number of males there and the lesser number of females there. So, for example, if you try to see the positions of power and visibility, for example, the chancellor, the vice chancellor, the proctor, the warden, the chief warden, such important positions of visibility and power which display power and strength, those are disproportionately occupied by males. And the menial administrative and clerical work is occupied more by females. So this is not my presumption. This is just one study that I recently read, which I'm sharing right now. So one alternative, of course, is to see the gender profiling and to have more women on board to understand and address the situations that they face. Because less number of women also ensures that less number of women will stay, and less number of women will be encouraged to join the profession. So yes, having gender profiling is one very important thing. Second alternative, I think, to display the gender profiling on the official website of such institution. Third, I believe, is to have for having a safer environment, especially in the lines of our discourse today, to constitute ICC, which is Internal Complaints Committee, which is a mandate, statutory mandate again under the Prevention and Prohibition of Sexual Harassment at Workplace 2013. And then there are several guidelines. For example, if you see an international convention, there's CEDAW, Convention on Elimination of Discrimination Against Women. India is a party to it. So CEDAW has several articles and then several protocols which provide for small things like having gender friendly toilets, like having systems within the institution that make it easily to access by the female counterparts as well. So these are few examples from my side, but I think the list is non-exhaustive. There are series of alternatives that can be there to make the environment gender free and gender equal. But then yes, these all the examples that I'm sharing with you are the artificial ones. One strong thing that comes from within is changing our patriarchal mindsets. So that is, I think, the root cause that needs to be addressed, and it cannot be so easily addressed. But yes, that is one thing. We can have
Okay, ma'am.
another.
Yes. Ma'am, this is question from Moni Gautam. She asked that what is the difference between carceral feminism and carceral state?
Okay. So thank you, Mohini, for your question. Yes. Under the umbrella of feminist criminology, there's one small approach to address sexual violence, and that approach is carceral feminism. So carceral feminism is an approach which sees criminalization and prison as a solution for sexual violence. And carceral state is one state that believes in laws as the go-to solution. So carceral state is a state that tries to see criminalization of any act that is seen as problematic. So a state that believes in over criminalization would be an example of carceral state. We can take another question.
Yes, sure, ma'am. Ma'am, this is a question from one of our SOLS family member. Uh, how to deal with recidivism in sexual offenses against women?
Okay. So, can you elaborate on the problem? So, are we talking about the prosecution stage, or are we talking
Habitual
about?
or the habitual offenders, ma'am. About habitual
Okay.
offenders.
Yes.
About that.
So, I think, especially for the habitual offenders, law certainly is not the problem because of the term itself. So, if an individual is habitually disobeying a law or is habitually violating a law, we clearly know one thing for sure, that law is not the possible answer, because there's something that needs to be reformed. So for example, jail systems these days are adopting more of reformation techniques. More psychologists inside prison system are being appointed. For example, the Har jail in New Delhi has a psychologist, officially appointed psychologist. Many prisons have a mandate that psychologists has to be there, and maybe psychology would have stronger answer to this uh, habitual offenders rather than law being an answer.
Okay, ma'am. Ma'am, the next question is from Mr. Saraj Singh of North Bengal University. And he asked that what should be our first step in deciding that we cannot simply reject the carceral feminism without first pondering over what the possible alternatives could be. because he says that it would be pointless if we cannot use the same to carve out a path that helps us to move towards justice. So what should be the first step regarding this?
Yes, yes, thank you. So I totally agree with what you say. Uh, of course, carceral feminism is not the answer in every situation, but yes, given the situation, carceral feminism looks like a plausible answer in most of the situations. So we cannot overlook the importance of laws and criminalization in entirety. That, of course, is true. But then what are the alternatives? I would not say that I know the alternatives, because I talk about carceral feminism and the problems that are there, that carceral feminism brings along with it on board. Possible solutions, I so for example, the solutions that the answers that I gave to previous questions is the strong rooted patriarchal society and the social stigmas that we have built around concepts like profession. Parishkar sir, you need to mute yourself. It's echoing. Thank you so much. So for example, the social stigmas we have built around how a driver has to be a male and how a nurse has to be a female. Or, for example, when we think about, there's a wonderful article by Rohini Sen, who teaches in OP Jindal. Uh, Her article talks about how, when we think of a professor, if we close our eyes, we assume an elderly male with spectacles, with some gray hair. And it's very rare that we assume a female in that position. So these are the social stigma that are there, and this kind of imagination or thought cannot be changed and regulated by law. And this, of course, I'm not talking about sexual violence, but our day-to-day reactions and actions towards the opposite gender. So these solutions necessarily every time cannot come from law. Also, given the fact that law is overworked, so we already have too many laws. We already have lot of pendency of cases. We have uh, the judges mentally and physically burnt out due to the pendency of cases, and then increasing laws, whether practically can solve the problem, I'm not sure of the fact. We can have another question.
Okay, ma'am. Ma'am, this question is from me itself. I just want to ask you that, ma'am, we have seen the amendments of 2013 and 2018 also. Also seen that thing has stopped after that. We still are witnessing the cases on the rise. So, ma'am, what do you think that being on the deterrent side of the punishments and aggravating the punishment is the solution, or there has to be some sort of psychological approach which our jurists, our thinkers have to draw a line between, or a collab sort of thing has to be made? Because as we have seen that even the adolescents and the minors are also engaged in a and in a way or in a manner that it is gruesome, it is not like totally acceptable. So what is that thing you think that it can be a solution, or we can be close to the solution of this problem?
Yes, thank you for your question. So, yes, so as as I've already told that yes, carceral feminism is not the only solution, but answers have to come from various fields. So law works at intersection of society, of sociology, political science, economics, psychology, and other fields, morality also for that matter. And in debates of sexual offenses and gendered violence, morality is a very important element that we seldom discuss about. So as law sits at the interface of so many fields of study, the answer has to come from these intersections. It cannot solely come from sexual offenses.
Kindly be patient. We are having some technical issues. We are resolving the same soon.
Picking up from where I left, for example, if we look at the words that we use in our writing and talking and reading also, all of those words have strong gendered connotations and gendered history. For example, if you look at any act, any statute, the examples in law of contract, the illustrations of Indian Penal Code, or any other law, every illustration has a he and not a she. And it's rare that legal scholars point this out and see this as a problem. Every teacher in class, while teaching, uses more of he. Suppose Mr. A goes here, there is never Miss A who goes there. So our examples come from what we read, and whatever we read is extremely patriarchal. And the readings have a very strong bearing on whether a law will function or not. For example, after 2006, after the equal share was given to daughters in the ancestral property, if you see the ground reality of that laws, daughters value having continuing relationship with their brothers as a family rather than asking equal share in ancestral property from brother and making the brother sister relationship bad. So even when law is there, a female cannot claim because that would actually change the relationship that you have with your siblings. So what you read also defeats the law that you are making. And this is something huge that we don't realize. So, and this is only about law books. So, for example, if you see the books that are taught in nursery class to the kids, it is still that a man goes to work and mother cooks pancakes in the kitchen. So, to me, father and mother going to office and cooking pancake. Gender narratives have not changed. So starting from birth, a person, whatever he sees around him, all that is strongly patriarchal and strongly gender. And now, after 20, 50 years of living in this gendered society, every one of us wants whether it is possible. I don't know law, howsoever message, I don't know whether law has so much power to undo what has been so many years of life or not.
Okay. Thank you so much, ma'am. And indeed, our attendees will definitely get benefited by your words and insights. We sincerely thank you for gracing our event with your presence. Now, I would like to invite our respected in charge, School of Legal Studies, Professor Dr. Geeta Singh ma'am, for her kind and motivational words for our attendees and the vote of thanks for the speaker. Ma'am, over to
Thank you,
you.
Parishkar. Thank you, Parishkar, sir. Hope I'm audible to you.
Yes, ma'am. Loud
Yeah.
and clear.
So, a very heartfelt thanks to Swati ma'am. It was great hearing you, me for the first time, and my students and faculty members maybe for the second time in SOLS BBDU. I found that you had a very good research on the topic and you have studied a number of articles, which is definitely the need for every student and faculty. I think there is something lacking which the researchers today don't do. That is, they do not go into articles and recent, updates of the law. So I think from the presentation or the lecture delivered by you today, they'll get motivated to read good articles and understand the importance of papers which have empirical study. We in law do not, we have the habit of copying or doing a doctrinal research and ending up with a conclusion which is almost every time same. And we do not take up empirical studies and do not put in efforts to find out the actual truth, which the present day scholars should be motivated to. That's the reason how we, criticize law, find out the lacunas law. And very rightly said, ma'am, that there is something wrong, which I find also, that for every wrong, the solution is not law. You cannot always depend on law for every solution, and very well articulated by you and explained by you. So it was great hearing to you. Hoping to get associated with you in our near future events also. Thank you to all the participants for being there and hearing it patiently. I think you have definitely gained something very fruitful. Thank you to my team members, Parishkar sir for hosting the event, Mudita, the event convener, Rajesh sir, the chief committee convener, our department in charge, Trishla Singh. Most thankful to Sonali for arranging all the technical issues and solving it. She's always there with us for all these issues. So thank you all my faculty members for every time supporting me in whatever I think has to be done. I found you like my backbone. I cannot do anything without your support. So thank you so much, ma'am. Thank you, everybody. Thank you for sparing time. We'll meet again in our future events with a good topic on discussion. Over to you, Parishkar sir.
Thank you so much, ma'am, for your inspiring words. And thank you, Mudita, ma'am, for your cooperation in organizing this event. And at the last, when we conclude, this is to all of the women out there. The sky is always yours. It is you who will choose at the end to fly like a bird or shine like a star. With that, this is Parishkar Shresht signing it off from today's event. Hope to see you soon in our next event and better tomorrow for all of us. And just a reminder that all our registered participants will be receiving their e-certificates within 15 days, subject to the filling of the feedback form. Thank you all. Until then, stay safe. Thank you, ma'am.
Thank you, Swati ma'am. Thank you, Geeta ma'am.